Senators, we will turn to tab 2, which is Senate Bill 1606 by Senator Grahl. Excuse me. Oh. Patient access to records. Senator Grahl, you are recognized on the bill. Excuse me, Senator Grahl, could you check to see if the mic's on? It blinks at you. Go ahead.
A patient
Now it's on. Yes, ma'am.
A patient will receive treatment from a multitude of healthcare providers in a lifetime. Each provider will create and maintain a record of treatment. It is crucial that each of the patient's current and future providers have the patient's prior treatment records for the patient to receive the best care. Patients don't automatically get copies of their records. Generally, they have to ask for them. Requesting records should be a straightforward process, but Florida law is inconsistent and confusing. The right to inspect records, whether the records have to be produced in paper form or electronically, and the time frame to produce copies changes depending on what kind of facility or practitioner is involved. This creates unnecessary obstacles for patients and discourages active engagement in their treatment plans. Many providers use electronic medical record systems that have portals for patients to access their information, but not all do this. The bill removes these obstacles and empowers patients to be more engaged in their treatment by standardizing the way practitioners and facilities must provide records to patients. Standardizes the time frame that the healthcare providers and facilities, except for nursing homes, must produce records or allow inspection of records. Regardless of provider type, each practitioner and facility must produce all requested records in their possession within 14 days, allow inspection of all records in their possession within 10 working days. It aligns Florida law with federal law to require nursing homes to allow inspection of records within 24 hours of a request and to produce copies within 2 working days. Empowers patients to control their records in the manner most convenient and appropriate for them. Requires a provider to provide patients with records in electronic format, including web portals and submission to patients' electronic personal health records if the provider has that electronic health record system. I know you're in a hurry today.
Thank you, Senator Grahl, for that expeditious explanation of your bill. Expeditious. So we are there questions on the bill? We have one amendment. We'll take up amendment barcode 900268. Senator Grahl, you're recognized on the amendment.
Thank you. This amendment deletes section 10 of the bill to correct a drafting error that would have mistakenly subjected nursing home facility records to new provisions in section 408.833.
Thank you. Any questions on the amendment? Seeing none, do we have appearance cards on the amendment? No? Okay, I'll give a moment again. Is there a question on the bill? Does anybody have a question? Senator Grahl, Senator Harrell, you're recognized.
Thank you very much. I do have some questions, and thank you for taking my call
Senator
this
Harrell.
morning and having a very lengthy.
Senator Harrell, I think I missed a point. I think I said to say without objection, the amendment is adopted.
Oh, pardon me.
Now I'm back on the question. Yes, ma'am. It's all yours.
Thank you. I'm sorry I misunderstood. I'm trying to be quick, as I was instructed. Yes, I have many questions, and thank you for taking them earlier. I'm just going to really delve into the one on, can you explain, please, what the difference between a personal representative is and a legal representative, and kind of differentiate for us the powers of each? And the bill seems to take the place of patient personal representative and make it a legal representative. Can you differentiate those two areas and tell us what exactly the bill does with both of them?
You recognize Senator Grahl.
Thank you, Madam Chair. So, and I believe this is on page 9 of the bill analysis. The bill creates a definition for the term legal representative that is similar to the definition created for healthcare providers earlier in the bill. And under the bill and for this section, legal representative means a patient's attorney who has been designated by the patient to receive copies of the patient's medical records, a legally recognized guardian of the patient, or a court-appointed representative of the patient, or other person designated by the patient or court of competent jurisdiction. So all depending on the specific type of relationship, whether or not it's a healthcare surrogate, it could be a healthcare surrogate, it could be an attorney, it could be somebody next of kin who would have the ability to make the request if the individual was not able to do so or pursuant to a court order. So it just makes clear that there's different people who can request the records.
You're good? Follow up.
Yes, so if I were the legal representative and I was an attorney, could I make healthcare decisions? Would I be a surrogate? and therefore, because I'm a legal representative, be able to change the treatment of the patient.
You're recognized.
Thank you. Not under the terms of this bill. This does not expand the scope of the decisions that the attorney could make a patient's legal representative unless that attorney has been retained for that specific purpose or serves that role as a guardian or is handling the estate, and that's what the estate and the probate or the documents allow for, the surrogate documents or power of attorney is in place. It would all depend on the type of relationship in place between that attorney and the client and or the patient, whether or not they were able to act in healthcare decisions beyond just requesting medical records.
Okay, if it's okay, we'll go to Senator Berman. She has a question.
Go right ahead.
Senator Berman, you recognize?
Thank you, Madam Chair. Will providers be trained or guided on how to navigate the shift in confidentiality standards, especially regarding the behavioral health records?
You're recognized.
Thank you. I would imagine that it would happen the same way that we would implement any of our laws in terms of whether or not there was rulemaking that was necessary in order to communicate with any of the providers, the changes.
Follow up.
You're recognized.
Thank you. What liability will providers face if they accidentally disclose sensitive behavioral health information that was previously protected?
You're recognized.
This bill, I don't believe, does anything to change the liability that they would already face if they disclosed information that was previously not allowed to be disclosed.
One more question. Follow up. Thank you.
Okay, you're recognized.
How will patient consent be handled for the release of psychiatric, mental health, or substance abuse records under this new prescription, under the new provisions?
You're recognized, Senator Grawl.
Thank you. The bill still requires written request from the individual or the individual's legal representative, and that would likely be on the same type of form that most of these facilities require now, which is a HIPAA release.
Thank you.
I see no further questions. Are there appearance cards on the bill? There are. Shante Jones with AARP, waves in support. McKenna Davis, Alliance for Health Information Operations and Standards. Waves against. Cal Probst, Datavant, I believe is the name of. Good afternoon, you're recognized.
Thank you. Chair Burton and Vice Chair Harrell and members of the committee, thank you for hearing our testimony today. I'm here with Datavant Technologies based in Phoenix, Arizona, and we are a medical records company responsible for disclosing medical records on behalf of medical providers. That would be hospitals, health systems, practice groups, any provider. We've got providers in 50 states that we service. We're the largest in the country at handling this, and we handle disclosing records for all kinds of purposes. Basically, anytime that record has to leave the medical provider's facility, that's something that's outsourced to our company. So we handle patient requests, continuing care requests, insurance payer requests, life insurance requests, attorney requests, government requests, audit requests, you name it. Anyone who's requesting the record, that record comes through our hands first, and also from the Alliance for Health Information Outstanding and Operations and Services, comes through their hands first. We make sure that that record is protecting the patient's privacy and protecting their most highly sensitive information before it's disclosed. So we go through rigorous steps to make sure that we're complying with HIPAA and state privacy laws. Now, to that point, I want to say that we are HIPAA experts, and when I read this bill, there are a number of concerns that I have that I find inconsistencies with HIPAA. And quite frankly, there are preemption standards that would apply both when HIPAA would preempt state law or also conversely when state law could preempt HIPAA in certain circumstances where a patient is being given more privacy or more access rights under state law than they are under HIPAA. And in those situations, you would have a state law that preempts. When I look at some of this language, I see situations where, quite frankly, we would have HIPAA preempting this law on the day it's enacted. One of those provisions is regarding what is exactly considered part of the record. So this says that all records must be disclosed. Does that include metadata? Does that include who accessed the record and when they accessed it to make a change? It's not real clear. So basically, we would have to defer to HIPAA and say, well, HIPAA is going to say that we're going to disclose the designated record set. A designated record set is something that a provider has actually signed off on, said, I've reviewed this record, and I find this to be an accurate representation of my beliefs on this patient. They sign off on it, upload it to the electronic health record system, and use it to care for the patient. That is the designated record set. This bill actually says all records. I don't really know what that means. So in my opinion, that's going to be ineffective on the day that it's enacted. We also have this definition of a personal representative and a legal representative.
Mr. Probst, I hate to cut you off, but
Yes.
we have a lot.
I understand.
A little bit. So if you just have one quick point you want to make, then I'd.
Well, I will just say that the legal representative and personal representative there's a clear distinction under HIPAA between the two. And a personal representative can make healthcare decisions. It's on the HHS website, on their FAQs. You can see it clear as day. If there's any questions, I'll be glad to entertain them.
Thank you. We appreciate you coming
Thank you.
here today. And I'll just remind everybody today, we have a very busy agenda. I want everybody to be able to speak who wants to speak, but I'm going to ask you to keep it within 2 minutes to start with. So we next move on to Adrienne Morel. I don't know who Adrienne is. Waiving in opposition. Thank you. Senators, we're in debate on the bills or debate. Senator Harrell.
Thank you very much, Madam Chair, and I want to thank the sponsor for her discussion this morning. I had a long discussion on it. I have great concerns about this bill. I have not just the difference between personal representative and legal representative, but also in the timeframes that are built within this. And it is very problematic. I think it needs some work. I'm happy to work with the sponsor as we move forward, but today, I'm sorry, I just cannot support it.
Additional debate. Seeing none, Anhar, would you please call, oh, excuse me, Senator, I'm just like moving here. Senator Grall, you're recognized to close.
Thank you. I appreciate the feedback today, the conversations with the members earlier, especially Senator Harrell, and look forward to continuing the conversation in order to help individuals have access to their healthcare records in order to make the best decisions for them. That's
Thank you,
Madam
Senator
Chair.
Grall. Anhar, would you please call the roll on Senate Bill 1606?
Senator Berman? Senator Claudius? Senator Davis? Senator Gates? Senator Leek? Senator Osgood?
No.
Senator Passidomo? Senator Trumbull? Senator Harrell?
No.
Chair Burton?
Yes. By your vote, shows SB 1606 will not be is unfavorable. The vote is unfavorable as a committee substitute. Thank you, Senator Grall, for being here.